This is grouped with Amendments 8 and 9, and this amendment was tabled by Deputy Naughten at committee stage. I want to thank the Deputy for raising this issue and again for his contribution more generally with this legislation. The purpose of the amendment is to increase the time available to An Garda Síochána to take fingerprints and palm prints and photographs from a relevant offender from 3 days to 7 days. Amendments 8 and 9 are just related to this, the first amendment, as they seek amendment to references from 3 days to 7 that appear later on in the same section to ensure that we have consistency. So this is just an addition to it. Maybe if I could as well, as I didn't at the outset, acknowledge retired Sergeant John Hines, who's in the gallery, and just to thank him sincerely for his work and his contribution over the years, not just specific to this issue, but as a member of An Garda Síochána. So just to acknowledge and to thank him for his support. But this is a very welcome amendment. This is something we've taken on board since the committee stage, and my further 2 amendments are simply just to ensure that we have consistency throughout the legislation.
Minister, can I thank you for Minister, can I thank you for taking on board this amendment? So, look, I think this is very welcome legislation. I think it will ensure that for the first time ever we have effective sex offenders register in this country. And in order to have an effective sex offenders register, you need for the member of the force that's going to be monitoring the sex offender to be able to make contact with that sex offender, to interview them, to take fingerprints and photographs and so forth. And we come to the photograph issue later on as well, why it's so important that they're able to take that. And the difficulty is, Minister, the legislation as it was written up to now, and the argument that I made at committee stage, that 3 days wasn't enough. Even more so with the bizarre vote by the opposition members here earlier in relation to my previous amendment, that you have a sex offender released from prison, high-risk sex offender, and who is residing in some rural part of the west of Ireland, and that they can go to Wexford or Waterford or Cork, present there, and they have complied with the legislation. Now, having only 3 days then for a member of An Garda Síochána in the west of Ireland to go through the volume of notifications, identify that someone has moved to their area, and then track them down, give them notice to be fingerprinted and photographed, was too tight a window. So I think the 7 days is a more responsible approach in relation to it. And can I thank you, Minister, for accepting this amendment, which I think will strengthen the overall thrust of the legislation and assist the Gardaí in managing the high-risk offenders. While I know they make up a small proportion of the overall sex offenders, they do pose a significant risk in the community, and we need to give the Gardaí the tools to actually enforce that. Thank you.
I welcome this amendment, and as you say, I think practically it's something that will support the Gardaí in their work. Thank you.
The amendment question is that the amendment be made. Is that agreed?
Agreed.
So moving on now to amendment number 8 in the name of the Minister. Sorry, I beg your pardon. 7 and 8 and 9 were all together. So yeah, so that amendment 8 be made. Is that agreed? Agreed. And amendment 9, the question is that the amendment may be made. Is that agreed?
Agreed.
So now moving on to 10. No. So in the name of the Minister.
Thank you, Last Concordia. I move Amendment 10. This section ensures that offenders who were convicted outside of the state are subject to the same notification requirements on entering the state as those who were offenders convicted here. This subsection aligns with the obligations of those convicted outside the state in terms of notifying the Gardaí of their name and address along with the date of entry into the state within 3 days with offenders convicted inside the state. The purpose of this amendment is to oblige those offenders who are coming into the state to notify An Garda Síochána of all their previous addresses since their conviction for the relevant offence. An Garda Síochána would already have this information for those who are convicted in the state, obviously, as these individuals will have been notifying since conviction. So again, this is at the request of the Gardaí to make sure that those who are convicted outside of the state but come into the state, that they're subject to the same type of requirements. Thank you.
Okay. So the question is that the amendment be made. Is that agreed?
Agreed.
So moving on to Amendment 11 in the name of the Minister, and 11 to 33 inclusive are related. 21 to 21 to 23 inclusive are physical alternatives to 20. 32 is a physical alternative to 31. 11 to 33 inclusive will therefore be discussed together. So just to note that if anybody's making a contribution.
Thank you. I move Amendment 11, and as you've just outlined, this is being discussed with Amendments 12 to 33 inclusive. Amendment 12 is a substantive amendment in this grouping. It deletes the original provision under subsection 14D that concerns the disclosure of information relating to a relevant offender to police services or other law enforcement agencies outside the state. This was to allow An Garda Síochána to enter into agreements with other police forces to share information on sex offenders. However, on the basis of further consultation with An Garda Síochána, this section we now know is not required, as there is already legislation in place surrounding the sharing of information with other police forces, which is robust, and agreements already in place obviously should not be jeopardised. Amendments 11, 13, 15 to 19 inclusive, 21 to 31 inclusive and 33 are then all technical changes that arise from Amendment 12. These deal with the numerical, grammatical changes wrought by the deletion of 14D. So, for example, the original 14E will now be 14D, 14F will now be 14E, and so forth. It's just a very technical change. Amendment 14 will allow An Garda Síochána separately then to provide a photo as part of any necessary disclosure where there is a risk of harm to the public or a member of the public by an offender. This amendment will contribute to the further protection of our communities in relation to disclosures and will be in addition to the information already provided by An Garda Síochána about a registered sex offender to a member of the public where deemed appropriate to do so. This again is an amendment that came on foot of a discussion with Deputy Naughten at committee stage to make explicit that a photograph could be provided as part of the information which is disclosed. The bill had provided generally for any other information deemed necessary by the Gardaí, but specifying, I think, that a photo can be provided is an important measure. So again, just to thank Deputy Naughten for his proposal and for his continued support in this bill. So the first part is very much so that we don't replicate or in any way jeopardise a legal system and structure that already exists within the Gardaí. And the second main amendment, separate to the other technical ones, really is to make sure that a Garda, where they deem necessary, can provide a photograph if they deem that somebody is in danger or that there is an immediate threat. And again, I thank Deputy Naughten for putting that forward. Thank you.
Minister, just to clarify that you are satisfied that the other provisions in legislation already will ensure that that reciprocal arrangement will be in place in terms of the common travel area and outside of that more generally. Just if you can just clearly clarify that. In terms of Amendment 14, look, I welcome the provision in relation to this regarding the provision of a photograph of a convicted sex offender to a third party where that is necessary in identifying them and in protecting either a vulnerable adult or a child. And in relation to that, Minister, and look, I'm not going to dwell on it, but I am going to highlight it again, and that is Amendment 20 in my name. I don't think that the convicted sex offender should be given notification in relation to this. So, you know, take the most likely scenario, and the most likely scenario is that you have a high-risk sex offender who's involved in a relationship where there are young children and where that sex offender has exploited young children in the past. Now, to contact that sex offender and tell them that you are going to inform the person they're in a relationship with that they have that conviction and that there's a risk there to those children, I think is only going to drive that individual underground, and I don't think that they should be given that forewarning, so to speak, in relation to it. And I will be pressing my amendment number 20 in relation to that. Amendment number 32 that I have tabled is in relation to the provision in section 13 of the bill is that the Commissioner shall publish or cause to be published information that he or she considers appropriate in setting out the manner in relation to sections 14D and 14E, which is in relation to the disclosure of information. What I'm saying is all of the information available and collated under all of the sections 14A to E, that data should be made available. I think it's important in terms of monitoring the effectiveness of this legislation, ensuring that it is kept current and up to date, that there are any weaknesses in the implementation of this particular legislation, that could be identified through making those statistics available. And I believe that it needs to be far broader in relation to what the Commissioner must publish in relation to data, and I'd ask you to accept my Amendment 32 in relation to that. Thank you.
Minister, did you want to come back?
Maybe just in relation to my own amendments and the changes. So again, I suppose there were concerns that what we were proposing would in some way jeopardise the system that's already in place. As it currently stands, the sharing of information regarding sex offenders travelling into and out of the state, it's carried out by way of police-to-police information, so intelligence information exchange via Interpol, allowing the relevant police forces to manage the risk posed by such individuals while they're either resident temporarily or indeed permanently in a different jurisdiction. Memorandum of Understanding was signed in 2006 between the Irish and the UK governments, specifically to ensure the sharing of information between the different organisations with regards to sex offenders. And then in 2008, an agreement relating to sharing of personal data with relation to the investigation of sexual offences and the monitoring of sex offenders was signed by the Police Service in Northern Ireland and An Garda Síochána. So this agreement again provides for sharing of personal information through a single point of contact in both police services. And since Brexit, we have made sure that any of those MOUs or any of these cooperation agreements, that they are continued and that there's no lapse or that there's no challenge there in terms of the work between An Garda Síochána, the PSNI or the UK side either. So I'm confident based on this, but also based on discussions with the Gardaí, that they are happy with how information is currently exchanged and obviously would not want to in any way jeopardise the work that's ongoing there. In relation to amendment number 20, so I suppose this is something that we looked at carefully but sought advice from the Attorney General in terms of, I suppose, fair procedure, which each individual, irrespective of who they are and what they have done, has to be entitled to. So this is an opportunity for a person to correct the record if information is incorrect or it's wrong. I appreciate what you're saying, Deputy, and that if someone can be given a heads up or time to know that this is going to happen, but I think the most important thing is that if information needs to be shared with a person, that it's shared with them. So if it is a woman or a man in a difficult situation or something comes to light, the most important thing is that the Gardaí share that information with them. The requirement to, I suppose, inform the person that they are sharing the information about. Again, as I said, this is clear from a constitutional perspective. It has been outlined clearly to me from a constitutional perspective. It's something that we need to do. I would stress though, and there is an element in this, if there is an immediate danger, if there is an immediate threat, the Gardaí can bypass that. So if they feel that by telling the person that they're going to make this information available to somebody else, that would pose a risk to somebody in a similar household, be it a child or anybody else, they can bypass this. So there is always a provision there to make sure that there's a safeguard to protect people. But if it's a case they don't live together, they're not in the same town, they're not engaged, or they're not, there isn't an immediate risk by them actually notifying them, then that's the route that they have to go. But there is a provision here that says very clearly, if a woman, a man, a child, if somebody is an immediate risk, they can tell them directly without actually having to raise it with the person first. So I think that's a really important provision here. On your second point though, if I could just, and I think it's more technical piece, so in relation to Amendment 32, looking to expand the information that the Commissioner can publish. If you look at 14A to 14E, so 14A relates to interpretation, 14C provides for the Minister to make regulations, so I don't think it would be practical for the Commissioner to be publishing this information. 14B concerns the composition of the SIRN teams, and they're already available on the Garda website, so that's already public information. The bill already allows for the Commissioner to publish information on how disclosures to the public will operate, and this still stands in what was 14E. So that's, I suppose, why I'm not accepting it, because I think that the specific parts that you reference, some of it's relating to the Minister, so it wouldn't be appropriate for the Commissioner. Some of it's actually already available, and one part of it is actually more interpretation. I do think what information the Commissioner needs to provide, it's set out, and there is enough in this legislation to make sure that the Commissioner can provide as much information as possible where there's a risk or a harm or a threat to somebody.
Minister, I just want to come back on one point, and that's on Amendment 20. You're saying that it's important that the information is shared. And look, I acknowledge this legislation provides a legal mechanism for the Gardaí to share information for the first time, which wasn't there up to now, and expose members of the force that provided very relevant and valid information. But this is my problem, Minister, in relation to this. You believe that it's important that the information is shared. I agree with you. The difficulty is, though, that in the circumstances that I talk about, if that individual is given the 3 days notice in relation to it, they'll disappear. The immediate threat is gone. The individual will not be shared with that information. Now, what happens if down the road that individual then gets back into that relationship again, and on this occasion are very conscious of the need not to make sure that this is under the radar with the Gardaí, so the Gardaí are not aware of it? Because my understanding of the legislation as it is drafted is that where that individual hightails it and disappears and goes underground, then the Gardaí cannot disclose that information to the partner, and as a result of that will not be given what I believe is important information.
That's not my interpretation of it, Deputy. So if there is a risk identified, whether or not the person decides to leave a house or to disappear or to move away, that risk is still there. So it's still, there is still an onus, or there is still an opportunity for the Gardaí to make that person aware of what they were going to make them aware from the first instance. So that's certainly not my understanding. That's not as it is meant to be set out in the legislation. So if a risk is identified, that information will be provided to the person where they feel there is a threat or a risk. If the person disappears, and can I just stress, and I suppose it goes back to the original amendment as well, if somebody goes to ground, if somebody doesn't register, they are in breach. They are potentially facing a jail term again, and there's quite a severe penalty here. So it's not as though there is absolutely no penalty here. If a person breaches, does not register, disappears and does not comply with the legislation, there is obviously a severe penalty that is there.
But Minister, can you just double check that in advance of going into the Shannon, that is the case that you set out?
That is my understanding of it.
Because I think my interpretation is different, but I accept your bona fides.
Yeah.